All right, join in, guys, and you can drop USA if you can hear me and see me well. Today we have Judge Pappas with us. All right, I think Instagram is fine. Today I have to make sure that I'm well centered in the video. Hello all. Okay, let me invite Judge Pappas right there on TikTok so he can. Ooh, let me reduce this. Okay. Judge Pappas, you are welcome to today's live session. Let me add you here. Okay. Well, I hope you guys can all see me and hear me well. If you can see me and hear me well, please drop USA in the chat box. We are just about to get started. Drop USA, and that will give us a signal to go ahead with today's live session. We have a special guest today, guest who is known to many of you because this is the third episode of our Immigration Court series. No, okay. Let me mute you, Judge Pappas. When I'm talking, I'll mute you so that there's no echo, and then I'll unmute you just like the last time because it looks like there's a lot of echo once I don't do that. Let me shift this here again. All right, guys, please let me know if you can see me and hear me across social media. You can drop USA or an emoji of the US flag. All right, so we're back today with episode 3 of Immigration Court series, and this is one that you don't want to miss. We're featuring Judge George Pappas. He's a former U.S. immigration judge and current attorney at law, and he's helping us demystify and break down what really happens inside U.S. immigration courts. This is really good insight and experience. You're not going to get this kind of legal education or guidance anywhere. Okay, so we're going to just get started. If you know anyone who's navigating U.S. immigration challenges or has immigration court, make sure that you send them this link. We're going to be here once a month for this year, and we're coming up with something wonderful and meaningful for immigrants, also a very special package. We'll talk about it later, but let me just invite Judge Pappas to take the stage, and then we can get started with today's session. Judge Pappas, you are welcome.
Good afternoon, AK Poku. You able to hear me okay? Can you hear me?
Yes, I can hear you fine.
Okay, good, perfect.
You're welcome. It's a pleasure to have you here on our third episode of Immigration Court series. So let's just jump right into it. I'll start with some questions. We've talked a lot about asylum in past episodes, but just to ground everyone quickly, Judge Pappas, can you just walk us through what is asylum in practical terms? We know asylum is, protection for someone who cannot return to their home country because they fear persecution. Please throw some more light on that for us. Thank you.
Sure. Well, asylum is essentially a form of international and national protection for people who are fleeing persecution in their country. This goes back to the 1967 UN protocols, which was adopted by many countries and finally adopted by the United States into domestic law into 1980. So since 1980, the United States has become aligned with international refugee law. And essentially, if individuals are fleeing their country because of persecution on account of their race, their political opinion, their nationality, or their religion, or what we also call a persecuted social group, if you fall into one of those five categories, you can apply for asylum. If your fear of returning to your country or if your past persecution is outside those five areas, you will not qualify for protection under asylum. So it's really, really important that you hook up or link up or be represented by an attorney that knows these laws, because it's so easy to believe, well, I'm afraid to return to my country, I'll apply for asylum in the United States. It's not that simple. So if you fear returning to your country, that you will be persecuted, you'll be killed, you'll be harmed because of those five areas, then you should certainly seek asylum. It's there to protect you against persecution in your own country. And we as a country have an obligation not to send you back to countries where you are facing persecution. It's called refoulement. We have taken a legal oath as a country not to do that. The problem is our country is doing that right now in ways we'll discuss later on. But in a nutshell, that's what asylum is about. It's to protect people who are facing future persecution or people that have faced past persecution to seek refuge in the United States. Does that help?
Great. Yes, that's great. Wonderful. Thank you. And you did mention that the law requires that the harm has to be connected with one of the grounds. So it's really
Correct.
important that our viewers understand this angle. Now let's jump into a few topics that we've narrowed down. Let's start with domestic violence in asylum. When we talk about domestic violence in asylum, domestic violence claims, if someone is being abused or beaten at home, practically speaking, let's say they are in Africa or they're in Asia, and let's say they're a woman, and they're being beaten blue at home by their husbands. Can they seek asylum in the United States? What does it take to seek asylum in the US? What does it actually mean when we talk about domestic violence as a basis for seeking asylum in the United States? Let me unmute you.
It's a very good question, and it's a very important category, which comes up a lot. I've reviewed hundreds of asylum cases, and I could tell you domestic violence is certainly in the majority of the applications that I have reviewed. So what is domestic violence, at least in the asylum context? Well, you don't have to be married to the individual who is abusing or harming you. You're living together with someone that you have children with. That's a domestic relationship. If you've got children with the person who is harming and abusing you, certainly that begins to open the door to domestic violence. Did it happen one time and it never happened again? That's going to be a tough case. Has it happened over a period of time, maybe months, years, by the same person? Well, now the case begins to get stronger. You're going to have to explain exactly with specificity how you were harmed, how you were verbally harmed, verbally abused, physically harmed. You need to have details about how that happened over time. Also, do you have any witnesses that saw how you were abused or harmed? Those witnesses are going to become critical to support your claim for asylum. You can get letters from them later on, but they have to also provide specific information about what they saw, not what somebody else saw. So witnesses are going to be very important. Were you harmed? Did you suffer bruises? Were you stabbed? Did you suffer scars on your head? Did you go to the hospital? Did you see a doctor? This is critical, because if you're a victim of domestic violence and you're claiming injury, physical harm, if you can document that harm, it's going to really strengthen your case. So, did you see the doctor once? Did you go to the hospital once? The more records that you have, the more evidence, documentary evidence that you have to substantiate your physical harm, the stronger your case becomes for asylum. And if you did go to a doctor, you want to make sure that the report of the doctor is consistent with the injury that you are claiming you suffered. If you go to the doctor and they're repairing your ankle, but you're claiming you got hit in the head, something's not going to work there. So you need to make sure that your medical records are consistent with the injury you are describing. So that's also very critical. The other key factor, especially with immigration law, is were you able to leave the relationship? Did you try to leave? And if you were unable to leave, why not? What prevented you from leaving? Did your partner lock you up in the house while he worked all day? Were there windows? You really have to document or explain reasonably why you could not escape such a domestic violence relationship. So that's going to be critical, because under asylum law, one of the key things judges are looking for was whether you could leave the relationship. If you were able to leave and go to your parents' house, did the abuser follow you? Did they find you? That's very important. So in terms of the domestic violence relationship, being able to leave or escape from relationship is going to be important for you to describe. Again, could you have escaped? If not, what prevented you from escaping? You individually will have a different reason. There's no one answer for that, but you're going to have to address that question. So, I can go into other areas, were you able to relocate or escape to other parts of the country? Some countries are very big, like Brazil, millions of people. One of the judges or many of the judges will want to know, and the Department of Homeland Security will probably want to know why you couldn't relocate somewhere else. Were you tied to this one place? Could this one individual find you? Other factors that make the domestic relation situation more volatile and violent is gang membership. Was your abuser a member of a gang? And if so, which gang? And did other gang members help them abuse you? In many cases, that's the case. Is the gang nationally organized? Can they find you anywhere in the country? These are some of the questions you need to answer, because they affect a victim of domestic violence from being able to escape or leave. They fear death. If your abuser is part of a gang and they threaten to kill you if you try to leave, obviously that would be one reason why you can't leave. So again, the domestic relationship certainly should, one, incorporate children from the partnership. But if there are no children and you've been living together with this person for a long time, there's a relationship there. It's not transient. He's just a boyfriend or a girlfriend, and they stop and see you every now and then. You have to live with that person for a period of time to really constitute a relationship. And then within that relationship, if there's abuse and harm, then it becomes part of a pattern of domestic violence, which you then have to prove and explain and substantiate. So let's start with that.
Thank you, Judge Pappas. Okay, can you tell us, for domestic violence cases, from your perspective, from your experience on the bench, were there things that could make or break? I know you talked about. Let me mute you. I know you talked about some of the things that could help cases and that could buttress the claims of people, but were there some factors that could make or break the case, the asylum cases in court?
Well, the number one thing that a judge will be looking for certainly is the credibility of the person's testimony. You have to realize when you apply for asylum, you're filling out an application. It's called a I-589. And that application is going to ask you where you've lived for the last 5 years, where you've worked for the last 5 years, what other members of your family are still perhaps in that country. It's going to ask you what type of harm or fear or persecution that you've suffered. So you have filed this document to start the process. And then when you get to your final hearing, I can guarantee you the Department of Homeland Security, one of the first things they're going to do is to see if your answers are consistent with what you put in the application for 589. So if you are unable to match to a large degree the information that you put in the application, your credibility is going to go down. You need to remember what you actually wrote. What did you say in your application? Because if you don't repeat the same answers, I mean, you're allowed mistakes. That happens, especially on dates. But if in the main you can't remember the majority of the information you put in your application, your believability, your credibility starts to go down. And so credibility is so important, which is why you need to work with a lawyer to make sure that you understand what you are expected to tell the court. And what you tell the court has to be consistent, certainly with your application. That's number one. Number two, your explanations have to be plausible. They have to make sense. They have to be reasonable. So if you say that you've lived with someone for 2 years and they abused you every single week, perhaps they raped you twice a week, perhaps they took a large stick and hit you and you suffered injuries. If you received any of these, if any proof of these injuries, you'll be expected to have some evidence of these injuries. Did they leave scars? Then you should have photographs of the scars. Are the scars consistent with the type of harm you suffered? That's important. Are the physical injuries that you claim you suffered consistent with the medical or other evidence you have to show those injuries? If you keep saying that you were hit on the head, but we have no scars or any documents that show that you suffered injuries to your head, your testimony is not going to sound plausible. So any medical evidence should be documented where possible. Also, if you filed a report with the police, many times people don't, but if you did, you should have a copy with the court of that police report. And that police report should be clear about what happened to you. It shouldn't be just a complaint because someone's bothering you. You have to be specific. So if the police report provides specific information about what happened to you, your claim of harm or fear of harm is stronger. It's very strong. But when you come to the United States, you've already left your country. If you suffered years of abuse or harm from a domestic partner, that leaves significant psychological harm on any individual. It would really help your case to go see a professional social worker who's licensed, or a psychiatrist or a psychologist, someone that can evaluate you and give the court a professional assessment of how you have suffered because of that abuse. If you suffered that kind of abuse and you've been here for a period of time and you don't have that kind of assessment in your evidence package, it's going to hurt you. A lawyer, a good lawyer, will make sure that you have an opportunity, or at least you are told to be aware of that kind of evidence so you can go get it. Lawyers will be your guideline. They'll be your guiding star. They'll be your quarterback to help you gather all the relevant evidence that the court is expecting. But if you don't have that kind of evidence, your case is going to get weaker. If you don't have any evidence of any injury, your case is going to get weaker. If your statements during testimony are inconsistent with your asylum application, your case is going to get weaker and weaker. So there are so many ways that your asylum application become weaker, or if you do the things I just said, it becomes stronger. So that's something you should be very aware of. And don't wait until 2 months before your asylum hearing to start gathering documents. You need time to collect letters or statements or affidavits or declarations from friends or family or witnesses or colleagues who can describe what happened to you. The more witnesses you have that remember what happened to you, the stronger your case becomes. Maybe some of them could be available for testimony on WebEx. So again, having third party or other people who can remember what happened to you, what they saw, is going to help your case. If you don't have any of these letters, it's going to hurt your case. Last but not least, if women in your country have been treated less than dogs, if they have been killed solely because they've been women, there should be country condition reports which talk about what we call in the profession femicide, the killing of women by virtue of being a woman. Statistics are kept by the U.S. Department of State, or at least they used to. Amnesty International, Human Rights Watch, other groups that have reports on each country to situate what happened to you. So if you were claiming domestic violence, which is not one of the official protected grounds, it would fall under what's called a persecuted social group. And I will tell you, despite recent Board of Immigration of Appeal decisions, which are being appealed, a judge has the legal obligation to examine each case on a case-by-case basis. For a judge to say, well, women cannot possibly be a persecuted social group is going to be something you can appeal in federal court. Because if a judge does that, you better appeal that judge's decision. I know in the First Circuit that women as a class are not precluded outright. The First Circuit has said that everything has to be examined on a case-by-case basis. So those country reports that speak about how women are treated, especially if there are laws in that country, because if there are laws in the country which seek to protect women, then I can tell you that your claim to have your gender as a persecuted social group starts to increase, because you've seen that the government in that country has identified you as an immutable characteristic. There was a case called Matter of Acosta. What's happening to you is immutable. It can't be changed. You can't change the fact that you're a woman in a domestic relationship. Your sex and gender can't change that. You're victimized because of that. And you have to be defined within a certain class of those women of being abused. And if your government recognizes that domestic violence is a subset of being a woman, it's going to get easier for you to claim that that type of persecution is what we consider a persecuted social group, which increases your chances that the court will grant you asylum. So there are many, many, many things you have to do. If you try to do this on your own, the chances are very high that you will fail. The statistics bore this out. The people that have success are normally and usually represented by lawyers. I'll leave it at that.
Great, thank you. I'm having to juggle muting and Facebook so that the sound will be clear. So bear with me if there's a lapse there. That's really, really interesting and important. Yes, the domestic violence as a basis for asylum is tied to the particular social group, one of the 5 grounds we've been talking about in asylum. Thank you so much for all of that. Now let's move on to political opinion claims in asylum. It's really misunderstood. It's one of the grounds that is really misunderstood. Some people think, well, if you have an opinion, then you can qualify for asylum in the US. What does political opinion mean? How can somebody identify that they have a political opinion that is a viable basis for seeking asylum in the United States?
Very good question, and it does come up often. I've handled political opinion cases from the Democratic Republic of Congo, Uganda, Angola, Central America, some in Brazil. So I've handled political opinion in many countries, from many countries. But what is it? Well, here's what it's not. Your individual opinion that you have to yourself. If no one knows about your personal political opinion, it's not going to work in asylum. And so if it's in your head and doesn't go anywhere, don't even try it. If, however, you express your opinion, let's say as a journalist or as a political leader or as an activist, and you're holding up a sign, you're writing articles, you're making speeches, you're part of a political party, you're campaigning for a political candidate. Now your political affiliation, your political opinion is now public. And if because of that public stance regarding your policy position, regarding your political support for a particular candidate, or even an op-ed article, for lack of a better term, once these are public, if you then find that you have been arrested, if you've been tortured, if you're threatened because of those opinions or because of your physical participation in protests in public, if that relationship between your public opinion, your public protests, your public participation in political events, if you are being threatened, let's say by the government, for those activities, then your case to claim asylum based on political opinion begins to have traction. It's got to start there. It's not enough because you're going to have to show a lot more evidence, but it has to start there. So remember, it's not your personal opinion that you have in your mind. That's not going to work. It has to be a known position. You can even seek to claim political opinion if someone in your family is being persecuted because of their political opinion. And the government now says, because you're part of that person's family, we're also going to persecute you. So your family membership can also link you and tie you into the political opinion asylum claim. So once you've established how you are being persecuted and on account of why, now your job is to prove it as best as you can. I'll give you an example. We have many cases out of the Democratic Republic of Congo where people are participating in protests. And during those protests, they are arrested by the police. They are put in a van. They're driven to some location. It could be a jail. It could be a building. And they claim that they have been tortured, not only one day, but weeks. And that torture takes place several hours a day. And obviously, not only is it physical traumatic, it's psychologically traumatic. And eventually they come out. Their job is to explain what happened to them physically and verbally and psychologically, what happened to them when they were detained. Your explanation of what happened to you needs to be specific. How did you escape? Were the police able to let you go on their own authority? Did someone pay someone off to get you out? You have to substantiate these. Did a relative pay someone in the government? Did they bribe them to get you out of the jail? Was your accent part of an ethnic or tribal group that one of the guards heard and they decided to let you out? All of these things need to be explained. But as soon as you get out, what happened to you? Remember, you said you were tortured for days, weeks. Did you go see a doctor? Did you get medical treatment? How did you leave the jail where you were persecuted? Did someone pick you up? Was it a car? Was it a taxi? Was it a motorcycle? Where did they take you after you left? Do you see the narrative here? It has to make sense. If you did go to a medical facility, did you get any medical report? Many people do. And that report has to be consistent with the injuries that you suffered. Did you leave the country right away? Or did you wait, 3 years to leave or 4 years to leave? I can tell you this, if you were persecuted in June of 2021, and you left 5 years later, you're going to have to really explain what you did for those 5 years and why it took 5 years for you to leave. I'll leave it to you. The sooner you leave, obviously, the stronger your case. And then you'll have to explain how you left. Who got your visa? How did you get through customs at the airport? Was somebody bribed? All of these things have to be part of your narrative. And so political persecution starts with harm and threat based upon your public opinion, your participation in rally. But your job is to finish your application with evidence to show not only why you were persecuted, but how, and with documentary evidence, witnesses, medical reports. Did you file any police reports that complain about the abuse? Anybody that can authoritatively Give details of what happened to you along your torture journey. It's critical. Was a family member the reason why you were persecuted? Who was that family member? How long were they persecuted for? Did they ever get jailed? And if you, as a family member, were persecuted, did you get any letters threatening you? Do you have copies of these letters? Did anybody else see these letters? You can see how important it is for you to document what you say. I can tell you that in theory, if you have no documents, certainly if your testimony is very strong, logically consistent, reasonably well balanced, you can, in theory, be granted asylum. But that's a very, very difficult thing to do. So your political opinion has to be known. It can be done through expressing an opinion. It can be done through your public participation with campaign rallies or supporting candidates. If you're campaigning for a party and you're claiming political opinion persecution, we're going to want to know, did you let somebody in the political party know about your persecution? Did you let them know? You didn't tell anybody? You mean you're saying that you're persecuted because you're supporting a candidate, you're part of a campaign team, somebody from the opposition party has threatened you, and they told you to stop putting flyers on walls and poles, but you never told somebody in your party that you were being persecuted? That's going to sound pretty strange. You would certainly tell them that you're being persecuted. Maybe they could help you. Maybe they could protect you. But to have no evidence that you even mentioned this to your political members in your campaign is going to be a problem. It's going to hurt your credibility. So those are some of the ways that you can identify political opinion. And what I've also described as some of the ways that you can try to prove your persecution based upon your political opinion. It's going to be based upon getting evidence, or you're going to be hurt if you don't get certain kinds of evidence. Let's take it from there.
Thank you. Thank you. Okay. I think you've mentioned from your perspective which cases or what kind of evidence distinguishes a strong political opinion asylum claim from a weak one, all based on your evidence and things you're submitting. Okay, thank you. Let's move to indigenous claims. Please, Judge Pappas, explain to us what are indigenous claims. Tell us about that. What does it mean to somebody watching in North Carolina or in Nigeria or in China? What does an indigenous claim for asylum mean? What ground, which of the grounds does it fall under? Tell us some more about that.
Well, to my American viewers, if you're watching this, I'm going to ask you one question. Can you name the largest group of people who would be considered refugees present in the United States? They're going to say maybe Mexicans, Brazilians, African countries. They're going to say, I don't know, people from the Middle East. No, they're not the largest groups. The largest single persecuted group are Native Americans in the United States. Most people don't know that. They are the largest displaced group in the United States. We don't normally think of them as displaced people, but they are indigenous. And other countries, virtually every country that I've seen, has an indigenous population that preceded the settlement of colonial powers. Throughout the entire Western Hemisphere, that's the story. There were indigenous people here before Portugal arrived, before Spain arrived, before England arrived, before France arrived. Yet when those countries arrived in the Western Hemisphere, they didn't consider those people Christian. They didn't consider those people human. All of the Europeans considered these lands as terra nullis, vacant of human existence. So if we saw them, according to the Pope Alexander in 1453, the Pope said to the European powers, if you see these heathens, you can kill them, you can vanquish them, you can conquer them. This was religious law that became known as the doctrine of discovery. This was the beginning of the Western Hemisphere genocide. Well, the genocide of the indigenous people in this hemisphere has been going on certainly since the late 1400s. The same thing has been happening around the world whether it's the Middle East or whether it's African nations. Indigenous people have been discriminated against, have been killed solely by virtue of the fact that they are seen as less than human, maybe because of their skin color, maybe because of the language that they speak, an indigenous language. So, race is one of the protect grounds under asylum. And if you are part of an indigenous group and you have discriminated, you have been harmed, or you have not been protected by your government, or the government is unwilling or unable to protect you because of your indigeneity, that is a strong starting point to seek asylum based upon your indigenous status. Of course, if you're a female, part of a domestic violence relationship, that would be another ground. But let's just stick with indigeneity. Well, certainly you're going to have to prove that you are a member of the indigenous class. Do you speak the indigenous language? What other markers prove that you are indigenous? Is it your skin color or your language? Or are you a member of an indigenous community in your country? And so if you can connect yourself to these areas as being indigenous, and then you can show that the police will not protect you, maybe against gangs because of your indigeneity. Maybe the police will provide more protection to a non-indigenous part of the country, but not for you. And if you therefore say, look, I can't go to the police, I'm indigenous, they don't protect us, I have proof that they won't help us. Our community is on its own, it's vulnerable. So you're being discriminated, harmed because of your indigeneity. You can't also relocate so easily, perhaps in other parts of your country, because you're seen as indigenous. People are going to discriminate against you in terms of employment or schooling or other areas. I can tell you countless ways that indigenous people are harmed, both physically and also psychologically. So the indigenous issue is prevalent in virtually every country that I've reviewed. Once the individual can prove their indigenous membership, it then becomes a question of how was that harm connected to your indigeneity? Were you assaulted on the street because of muggers? That's not going to work. If you're a victim of general crime, your indigeneity is not going to save you. But if you can show that only or mostly indigenous people are robbed in a country or abused physically or killed or harmed, if you can show that pattern that mostly indigenous people in a certain area face threats that others don't, well, now your case starts to get higher and higher in terms of plausibility. So the indigeneity issue, AK Poku, comes up a lot. And I can tell you it's a very powerful claim for asylum, but not all indigenous people prevail on asylum because the ones that don't succeed are unable to connect their past harm to their indigeneity. If they keep claiming that they were blackmailed because they borrowed money from a loan shark, well, the loan shark is threatening with death, not because they're indigenous, but because they have a debt. Obviously, that's not going to be covered under asylum law. Owing money to a loan shark is not going to help you. But that's an example of where you could be indigenous and still not succeed. So you have to make sure that the harm, physical and psychological, is connected to your indigeneity. I'll leave it at that.
Great, thank you. Okay, now let's move on to let me ask this under the indigenous claims. Some of these cases may lack documentation, I guess, and I'm sorry, guys, and they may, some of the claimants or the people, the respondents or immigrants who are applying for asylum, they may rely on testimony, country conditions. Please just tell us how you approach or how did you approach evaluating these cases when you're on the bench, especially when evidence was limited for these indigenous claims specifically.
Well, there's a couple of ways that someone can still obtain an asylum grant if some of these documents are missing. Let's talk about what's called humanitarian asylum. Humanitarian asylum means that your past harm, your past persecution was so severe that even though if you go back to your country today, you wouldn't face the same type of abuse. However, because of the trauma from the past being so severe, the court's going to give you what's called humanitarian asylum because the mere fact that you're going back to that country is going to be too traumatic. So, how does that fit in with your question if they lack certain documentation? Well, let's say you don't have witnesses because what happened to you was when you were a child. You were too young to get witnesses today. It could be 20 years after the fact. Clearly, a psychological clinical assessment in the United States is going to be so important for you to give to the court to show how plausible your past harm or persecution was, especially if you were a child. And people should understand that any persecution as a child receives enhanced weight by the courts. So that's very important. So you may lack witnesses, but you can make up the difference with a very strong clinical assessment, which clinically substantiates through testing what happened to you. And if what happened to you was so severe, even if today you go back, you don't face the same persecution because of the severity of the prior persecution, especially if you were a child, is enough to grant you humanitarian asylum. So that's one way that you can still get a grant of asylum if you're missing certain documentation, let's say witness letters, or even medical letters, maybe physically raped, harmed many years ago, but it was very severe. But you don't have that medical evidence today. Certainly, any kind of medical and psychological evaluations are critical. I've received situations where people have claimed they have been raped. They have no documentation from their home country. However, medically, they've gone and gotten an assessment, and those professionals who examine victims of that kind of physical abuse are able to provide medical substantiation of what happened to that person, and it lends weight, it lends credibility to the allegation that they were raped. So there's other ways to make up for missing documentation from the home country in the United States. Those are some of the ways you can get around the lack of evidence from the home country and producing evidence from inside the United States. Psychological evaluations, clinical assessments, medical evaluations are all part and parcel of some of the ways some immigrants have been able to overcome the lack of evidence from the time of their persecution or from the source of their country.
Thank you. Now usually we take questions at the end, but we have this question. I think we can fit it right in. This is from Nikki on YouTube. She says, please talk about FGM, female gender mutilation. I'll tell you that's a really good basis for asylum, but I'll let Judge Pappas talk some more about FGM from his perspective on the bench as a former U.S. immigration judge. Judge Pappas, tell us some more about FGM and how it fits into an asylum claim.
FGM comes up frequently. Obviously, many African nations have tribal and religious reasons for doing this to women. And certainly, it's a physical attribute. It's physical harm. It's forced on women, girls. Certainly, you want to document medically what happened to you. This is where country reports also help because they will talk about these tribal traditions or religions that persecute women, and the FGM, female genital mutilation, is rampant. And so you need to substantiate the cultural aspect of why this occurs in certain countries. To just say it happened to you and nothing else is not going to be enough. So there's going to be plenty of documentation from country reports, Amnesty International, Human Rights Watch, CIA reports that all talk about which countries are rampant in inflicting FGM harm on girls. And the tribal aspect, the religious and cultural aspect is so critical in showing how these women are trapped. They're trapped by the cultural straitjacket of doing this to women. If they marry perhaps the wrong tribal member, that's also the basis of many tribal retaliations. But FGM in particular is a specific practice. It's abhorrent, but it's recognized. And it's a persecuted social group that is easier to identify as a persecuted social group than, say, other claims of PSG. I'm sorry, persecuted social groups. So the combination of medical evidence to show what happened to you, how your body was mutilated because of those religious, cultural, and tribal reasons, and also witness accounts from people that know about those traditions, when it happened to you, by whom. Was it because of the family? Was it because of a priest? Someone decided that they were going to do FGM to you. And of course, if it didn't happen to you, you fear that it will happen to you. Those country reports and those letters from neighbors or friends or other people in your community or in your country are going to be so critical. So it's either it happened to you, FGM was inflicted upon you, you weren't protected by the government against those actions against you. The government is unwilling to help you because of maybe tribal traditions, cultural reasons. Maybe the government is dominated by those people who believe in those cultural conditions. They're not going to help you. They're not going to protect you. Your persecution is going to be horrible. Or you fear it is going to happen to you. And again, all those cultural and political reports and information are going to be critical to situate why your subjective fear is objectively reasonable. This is a key phrase in asylum law. It's one thing for you to fear subjectively this is going to happen to you, let's say FGM. You also have to show that your fear is objectively reasonable. And the way to do that is to get reports about your country, newspaper articles, professional assessments, other opinions from credible people to show what will happen to you and that your subjective fear is reasonable. That is so important because if you have no past persecution, you're going to have to evidence a reasonable likelihood that you will face X persecution if you return to your country. And your own fear is not enough. It starts the process, but your own fear, which we call the subjective fear, has to be evidence supported as being objectively reasonable by reports of what's happening in your community, in your country. Those reports could be from government organizations, from the UN. They could be government organizations or non-profit organizations around the world, like Amnesty International with human rights. You need those documentations, or you could have expert testimony that's familiar with what happens in that country, also provide evidence to the court. If you can do that, your case gets real strong for an asylum approval.
Judge Pappas, do you remember any striking FGM case that you ruled upon? You remember? Did I get interrupted? Do you remember any striking FGM claim that you decided? Can you tell us maybe briefly about that?
I'm trying to think of any specific case right now. Let me just quickly go through my memory banks.
Or even anything you learned about FGM that was so, perhaps shocking or wow, my goodness. That would be interesting to hear.
I would say that the ones that I had, all of them were able to show the mutilation. They had the medical evidence. Obviously, the more I looked into these issues in these countries, the more damning they became. The third party reports, State Department reports at the time, Human Rights Watch articles, expert testimony educates the court about what's happening to that particular person. Girls, very young, 10, 12, being plucked away from their community based upon their parents' preference to have their children mutilated in that way was pretty shocking. But the cultural and religious pressure is just so ingrained in these places. That's the reason why it happens. The tribal, cultural, and religious pressure. The court needs to know about those. Otherwise, they can't situate the individual claim for harm. the court needs to know about those other issues, the cultural, religious, and tribal issues, so they can see why the government won't protect these girls. That's the reason why. And so this becomes a whole human rights issue, obviously, beyond persecution. These governments are integrating cultural and religious preferences into their governance of countries. They're not protecting these women because it's so ingrained in their society. They would be voted out of power if they did. So the dehumanization, for lack of a better term, upon women is evidenced here. We're not talking about domestic violence. We're talking about a direct assault on a woman's ability to have sovereignty over her body, not only to have sovereignty, but to actually be attacked, mutilated, and then to have it sanctioned by cultural, tribal, and religious institutions. So the institutional support for these mutilations is the horror show. But that horror has to be evidence on a case-by-case basis. It's not enough to say that I was a victim of FGM and then hope that that will be enough to get you an asylum. Your lawyer is going to have to do that work and get that situational, institutional evidence into the documents so the judge can see it. Every case is different. There's no blanket answer on every case.
That's right. Thank you. No, the FGM is, let me just say to you here. I just pulled up the US government's position on FGM. Let me just share that briefly before we move on to the next question. FGM, this is from the USCIS website. It refers to all procedures involving partial or total removal of the external female genitalia or other injury to the female genital organs for non-medical reasons. It may be called female circumcision in some parts of the world. This practice has no health benefits and can lead to a range of serious physical and mental health problems. Now, you guys listen, the US government's view of FGM, the US government opposes FGM or circumcision, no matter the type, degree, or severity, and no matter the motivation for performing it. It considers it a human rights violation and a form of child abuse. It's against the law. You know, it goes on and on. Just to let you know, FGM is a very valid basis for seeking asylum in the United States. And as Judge Pappas says, it's not just about making a claim. You have to back it up with medical reports showing that you have actually suffered FGM. So that was a really good question. But yeah, if you have suffered FGM, then that's something that you can use to seek asylum. Obviously, we'll have to review that. But okay, now, Judge Pappas, let's go to the next question. Looks like we're running out of time. We probably may have to take some more questions from people. But let's look at our last thing: LGBTQ asylum claims. LGBTQ. Talk about that because LGBTQ is it can be complex. The issue of sexuality and gender and identity and what countries permit and what countries criminalize. And there's a lot of tension between countries. Some countries say, no, a man and a man should not get married. This is an abomination to our culture. Other countries are accepting of it. The United States is accepting of it. Some countries in the world are not. Some people believe that they are men, but they are in women bodies. Some people believe they are women, but they are in men bodies, or they have, a different sex than what they feel. It's a lot of confusion. And tell us some more about how LGBTQ claims can fit within the asylum framework.
Well, I'll give you one case example. We had an Egyptian man who, based upon his homosexual relationship with another man, claimed asylum or applied for asylum in the United States. All right. So his sexual preference, his sexual orientation was the basis for the claim. And that's certainly a starting point. And he had to show that homosexuality was something that was abhorrent in Egyptian society. He had to document that through his lawyer or through himself about what the cultural norms or legal norms were. And they provided documentation which showed the cultural persecution of people that were of that persuasion. He had to show what the government could not do or was unwilling to do to protect him. In fact, in his case, he had a government member, I'm sorry, a family member who was also a member of the police. Once his preference was revealed, his own family member began to persecute him, arrest him. Those examples of how actually he was persecuted once his sexual preference became known to family members was critical to his case. And he did not show that he was persecuted necessarily because of his preference. There were many opportunities when his so-called preference was known to other family members where he was not discriminated against. He was not forcibly hurt. He tried to show that friends discriminated against him. He tried to show that he was hiding his relationship, yet he was very open, he said, in meeting his partners at cafes or at parties. Yet he's also claiming that he couldn't do this in open because he would be persecuted. So there was contradictory evidence. On the one hand, he was saying, if I display this, I will be persecuted. On the other hand, he's openly holding hands in public and other embraces of his partner in public. And so the two just weren't mixing. They weren't consistent. If you feared open relations, then why are you saying you can do this? Not realizing that you're contradicting your own argument. So in this case, the cultural and political problems with gay men in Egypt is prevalent. You will have a problem. In this case, the individual could not produce evidence that was consistent with a homosexual relationship in Egypt. In Egypt, he had an open relationship, did not face persecution, yet talked about the fear of going back if he had an open relationship. So his personal evidence, his personal situation was not consistent with what the overall fear of being gay was in Egypt. He had a hard time proving that. That was a person who did not prevail. But what I'm saying is, if you do have evidence that shows that your persecution based on your sexual preference is proven in your case, plus the institutional and country condition reports and other friends' letters or any other clinical assessment that you can bring to the court, those other factors will then glue your personal experience as being bona fide, as being real, as being substantive. And so you have credibility. There you can prevail of getting asylum based upon your preference. It's not just tied to Egypt. It can be in Brazil. It could be other countries where homosexuality is abhorrent for religious or political reasons. So those are some of the examples that I've dealt with where they have not succeeded in getting a grant for asylum.
All right, thank you so much, Judge Pappas. Let's see if we have a couple questions. I think we already spoke about the FGM, which was related to what we're talking about here. Let me see if we have some related questions. Seth Ofusu on LinkedIn says, very educative. Thank you, Seth. Toklu She says, approved August 2025. I want to apply green card before August 2026. Do I need to wait full year? We don't know what was approved. It sounds like your asylum case. Judge Pappas, do you have any insights on that? I'm sorry. Okay, there you go. I think you are muted.
I'm not muted. Can you hear me? You able to hear me? I can't hear you now.
Yes, I can hear you. I'm sorry, I was muted just so that I don't echo.
Okay, my question was, what was the question?
Okay, so this how long after an asylum grant can you apply for a green card?
Was the question if you are granted asylum, can you apply for a green card? Was that the question?
Yes, how long
Yes.
after?
Yes. 1 year after you're granted asylum, you can apply for legal permanent residency. 1 year. It doesn't mean you'll be granted. It means you can apply. So that's the answer.
Yes, and the 1 year would usually be 1 year will be counted usually from the date the asylum was granted. But that's one of the interesting, that's perhaps the interesting differences between asylum and withholding of removal and convention against torture. Even though, for example, withholding of removal may have a higher legal standard, you don't get to apply for a green card. Can you just briefly?
If you are denied asylum, you're not going to get a green card. You won't be able to apply for a green card. You can then continue based on your application to seek withholding of removal or the Convention Against Torture. Withholding of removal has a higher standard. You have to show more likely than not that you will be persecuted if you go back to your country on one of the protected grounds. Not that you have a general fear of crime, that's not going to work. So you have to show that you will be targeted on one of the protected grounds in terms of probability, more likely than not, if you go back to your country. If you cannot show that you have a nexus, a connection, that you will be persecuted on one of the protected grounds, you will not be granted withholding of removal. The only other area that we have a chance would be called the Convention Against Torture. And there, if you have fear of any type of harm, not just a protected ground, and if it's reasonable, if there's a reasonable possibility that you will be persecuted for any reason if you return to your country, that's number one to look at for Convention Against Torture. You have to also show that either the government is going to persecute you for any reason, or that the government will do what we call acquiesce. They will acquiesce, say, to gangs or other people. They will sit back and tolerate that you will be persecuted by these other groups. If you can prove that the government will not protect you and will just acquiesce to your harm for any reason, then you have a good chance for a deferral of removal to that country based on the Convention Against Torture. The big sea change today, unlike the past, let's say pre-Trump 2.0, if you were granted Convention Against Torture relief or even withholding, you would remain in this country indefinitely. In some cases, you could even apply for work authorization while the government continues to defer your removal to that country because they may be seeking you eventually to remove you to another country. Today, the government has signed these cooperative agreements with 20 or more countries, and you cannot expect that you will remain in this country, even if you prevail with a grant from the Convention Against Torture, from going back to your country, because the government's going to send you to another country. This government has created a deportation machine. They out if you cannot prevail on asylum. It is very hostile. It is very difficult. So those are the other types of relief that you could ask for if you don't get asylum. In the past, they gave you some measure of protection. In today's environment, it has very little value for protection because the government's going to ship you somewhere else. It's horrible.
Thank you, Judge Pappas. All right, guys, it's already 2 p.m. I think we've answered a lot of your questions and we've discussed a lot today. You need any U.S. immigration assistance, please, you can contact us. Judge Pappas and I are going to come up with a really good package. Please wait for it for immigrants around the U.S. We'll be discussing that with you likely soon. So just stay tuned on how we can assist you guys more in a more efficient way, how you guys can contact us to get your cases moving forward, because we're seeing a lot of people in immigration courts getting their cases denied because they're not getting proper help. And once your case is denied at the immigration court level, the BIA, it becomes really difficult to have it overturned on appeal. A lot of the work and the heavy lifting has to be done at the immigration court level. And another thing that I was even talking about this, we talked about it on our social media channels. People are getting sent to immigration courts because their USCIS filings are getting denied and they do not have lawful presence. They are found to be unlawfully present in the US. It's a new policy since last year, February 2025. People still have not heard about it and they are filing things to USCIS without determining the best strategy, and they get denied, they're sent to immigration court, and that gets messed up and they're already on their way out of the country. You can do this with the right help. So we'll let you guys know. Let me just put out our numbers or our contact information also. Judge Pappas, was there anything you wanted to end with or say?
Laura, I just want everybody to realize that the U.S. government supports many of these governments which are committing persecution against their own people, whether it's FGM or the discriminations. The Democratic Republic of Congo is a classic case of where the U.S. is propping up a government because of minerals, ignoring all the human rights violations within the Democratic Republic of Congo, which is very huge. You have Catholics and non-Catholics, English-speaking, French-speaking within that country, but the government is overlooking all of that because they want the economic benefit. So while we find it abhorrent in terms of asylum applications of why people are forced to come here, let's not forget that the United States government is supporting many of these governments.
All right. Well, thank you so much for your amazing insights and for joining us today on this session, Immigration Court Series. We'll be with you guys live once a month, usually the last Friday of every month. Stay tuned. Judge Pappas, somebody was asking about CLP, Circumvention of Lawful Pathways. We can likely discuss that in our next session, along with other things that people have to know, what immigrants need to know before they get into immigration court. So hopefully we'll see you guys. And yes, if you also need help, I put up Judge Pappas's number, 828-903-8987. You can also contact AK Poku Law, 802-780-0564, or you can send us a DM and we will also be happy to assist you. Immigration is federal, so it doesn't matter where you're based. An effective or good attorney can assist you nationwide. All right, guys, thank you so much for joining us. If you have not followed our pages on social media, AK Poku, please follow. Judge Pappas is also on social media now, so go give him a follow. He's on Instagram, TikTok, Facebook, and hopefully we'll see you guys next week. Well, I will see you guys next week at 1 p.m. right here on social media. Take care, have a good weekend, and we'll see you soon. Thank you all. Bye-bye.